Oftentimes, in high conflict litigation, there is a huge concern from the parents that their children may not be safe if the other parent is playing games or simply using them as pawns to be able to continue controlling the parent with the children or to extend the litigation or seek something that they really shouldn't be getting, like 50-50 or sole legal physical. So in those particular circumstances, there is a fear that when children go off to the other side, that they're going to be utilized and controlled. And so there's a lot of things that can be done to help protect that. But the first and foremost is make sure that your own fears, your own thoughts of what is going to happen is not being projected on your children, meaning that if you're afraid of something, you don't want your kids to then feel afraid just because they see you feeling afraid. So that's number one, is not to put your kids in the middle. Number two is make sure that you're working with an experienced attorney who really understands the ins and outs of going up against somebody who is controlling and manipulative and somebody who is essentially high conflict, which could also be their attorney. And so when you have a situation like that, making sure that you're documenting the important aspects, making sure that if something happens, you're not necessarily taking a back seat, but you kind of have the ball in the court, and maybe you're the first one to go to the police if it's a situation that really needs it. Maybe DCF has to get involved. In court, oftentimes a guardian ad litem can be appointed, and that's just somebody who is appointed by the court to do a complete investigation and report back to the court on what they believe is in the best interest of the child. So there's a lot that can be done, and there's a lot of strategy that goes behind making sure that children are protected in high conflict situations.